Well, good afternoon, everyone, and I hope your afternoon is going well. Just wanted to welcome everybody to today's webinar on the topic of Psm in OSHA inspection from a former OSHA CHSO perspective, and essentially that's me. So today is an important topic to kind of discuss. If you've not had a OSHA Psm inspection before, we'll try to give you some insight into how that's going to take place, and then probably help and hopefully help you with that process along the way. So with that, let's go ahead and get started. If you have any questions, please feel free to put those in the Q&A area, and we'll answer those questions at the end. So let's start out with how that whole process works. And just we're going to briefly give you an overview of the whole process and the workflow and how that normally takes place, and then talk about each of those things individually. First, it's going to always start out with some introductions. You're going to have an OSHA compliance officer show up at your door at your business. They should be showing their credentials and state their purpose and why they're there to visit. And they'll want to see the most senior person in charge of the facility so that they can open the inspection. Part of the process, again, will be explaining why they're there. And obviously, this is going to be something we're going to talk about, and that's a Psm inspection. Part of that will be they may need the orientation, but once they do that, then they'll want to walk through your facility, your process, in particular the process itself. There'll be a document request of some sort. The number of documents will depend, of course, on the person doing the inspection, but also in the type of process that you might have as well. After some document review, then there'll also be some interviews. And then, of course, if there's any findings, there may be citations issued. And then there'll be opportunity for you to do an informal conference, contest the citations, et cetera. We're going to talk about each of these things individually. So the first thing is we realize, and certainly I realize, having been with OSHA before, that sometimes OSHA inspections can be intimidating. I've been on both ends of this, both from a standpoint of an industry where OSHA showed up at our door and did an inspection. And of course, I've been on the other side as an OSHA inspector and showed up at somebody else's door. But I will tell you this, and this is something I'm going to stress all along today as we go through this topic, is the key to the inspection is knowledge. Your knowledge of your systems, your knowledge of your processes, your knowledge of your compliance and how you comply with the various elements of Psm. Well, first of all, the inspection process. Things to always remember is to be cordial and treat people respectfully. The last thing that we want to do is put a compliance officer, doesn't matter who the regulatory or what regulatory agencies involved, being cordial, being kind, being respectful is the first order of business. When you're combative, then certainly it never ends in your favor. Don't make the CHSOs or the compliance officer wait. Show some reasonable amount of time before you allow them in to start their process. If you're having the compliance officer wait out in the hallway or wait out in the greeting area for an hour, couple hours, that's not going to bode well for you either. Show that you are organized. And what I mean by that is make sure that if you get them in there in a timely manner so that they can start opening their inspection, they can do their walk around, et cetera, it shows that you're organized, that you're prepared, that you know what you're doing. Remember, OSHA or EPA, it doesn't matter who the regulatory agency is, they're not the enemy. They have a job to do. They're just doing their job the best that they can. And then we have to, as an industry, work with them to make sure that we're being professional as well. So once you're in the CHSO or the compliance officer is in your facility, they'll start with introductions and of course introduce themselves. And I said as a compliance officer, they have to show you their credentials to show that they are actually a federal employee, and of course with OSHA. They must tell you the reason for the visit, whether it's an injury, whether it's a complaint, whether it's a hospitalization, like 3 or more, media event, etc. Any visit for any reason will result in an NEP as well. So what I mean by that, if OSHA shows up into your facility because you have an injury or complaint or hospitalization or a large media event, then most likely you will also be getting a chemical NEP inspection. So be prepared for that. So if you have an injury where OSHA is coming out, they should be doing a PSM inspection of your facility as well. Always remember the statute of limitations on all OSHA inspections. Statute of limitation meaning how long they have to issue a citation is 6 months. So as soon as they show up at your door and do the introductions and tell you why they're there, that clock starts then. I'll start out with some basic facility information gathering, trying to understand the facility, try to determine PSM coverage. There have been facilities that I know as a former OSHA inspector, I'd go into facility and establish whether or not the facility is even PSM covered to begin with. For a couple of reasons, they may not be. One is, for example, a lot of times ammonia refrigeration facilities will pump down their systems and find out they have less than 10,000 pounds, or they've reduced their inventory to below the threshold limit. Then you no longer can do a chemical NEP if you're below the threshold quantity of 10,000 pounds. Also, they may be a VPP site or voluntary protection program facility. It's the VPP site, then OSHA does not do chemical NEP inspections on those facilities. If they're not covered by VPP, then the inspection is done. They'll certainly will be asking for, and you should provide a process overview. Doesn't matter what kind of process you have, just giving them overview of what you do and the chemicals involved in your process. I always tell people in advance, plan the route. And begin, it goes back to organization. If you're organized, then you'll already be prepared for when OSHA shows up at your door, whether that's to do an inspection of just your facility or if they're doing a PSM inspection. Since we're focusing on PSM inspections today, have that route planned on how you're going to get to those covered facilities, how you're going to get to the roof of the facility, how you're going to get to the engine room or machine room, for example, how you're going to be going to the various parts of your process. Are you going to pass through uncovered parts of the process to get to the process that is covered? Just making sure that you plan that route accordingly, keeping in mind that as OSHA walks to those facilities, if they see any hazards in plain sight, they will stop and probably address those, whether that's in a discussion or it could also wind up in an actual citation. So the walkthrough will include all the covered processes. So if you have more than one covered process in your facility, most likely they're going to walk through all those covered processes. They may select one or more processes to inspect, and they may interview employees along the way. Typically, the interviews are not that long, but certainly they have the right, and they may very well interview employees as they do that walkthrough. They may interview contractors as well. I know that was usually the time as a OSHA inspector, I would like to interview contractors when they're actually on site. As you might guess, that sometimes when OSHA shows up, people scatter, people go home, people do things other than stay there waiting for OSHA. So that's certainly something that, again, if that's your plan, then you execute your plan. Always looking as part of the walkthrough, you're also looking for occupational safety and health hazards as well. So we're not just looking at PSM, different things in PSM as they relate to PSM, but also occupational and health issues as well. Electrical conduit broken, wires exposed, trips, slip strips and falls areas, fall hazards. The list can go on of things that can be seen in plain sight quite often. Also, I want to point out is always address the items pointed out by CHSO in the walkthrough. So if they come across something that they think is important, and they might point out and say, we see this as a trip hazard or a slip hazard or some other hazard, address it. Don't argue about it. Just go ahead and address it, because I will guarantee you they'll come back and look at it perhaps later on, or there could be a citation issued for it as well, depending on what the CHSO decides to do with that hazard. Show the CHSO that safety is important and it's a priority. If they point out a hazard and it's not addressed, then it shows what your priority is and that you're not really concerned about safety. Typical is if failure to address these is always going to be cited. I know that as a former CHSO, when I would do my walkthroughs, I would write down everything that I saw along the way or during the walkthrough of the facility itself, and write every one of those down so that when I would come back, maybe 2-3 weeks, sometimes a month later, I would ask to do another walkthrough. And during that walkthrough, I was looking to see whether or not those items had been addressed. And if they are not, they are always an automatic citation. The next thing that we're going to talk about is the actual document request. And if you've ever been in an Osha Psm inspection, you know that those number of documents can be quite numerous. Typically, they're anywhere from 40 to 75 different documents, and those could grow depending on how much embedded information was in. For example, an SOP would reference another document. You may have to do another request to get that document as well. Most times the document requests are formal, it's a letter, but they also can be subpoenaed. And I know that there are many areas within OSHA that they don't do formal letters. Everything is done via subpoena. So regardless how the information is asked for, need to provide every bit of it. Seek clarification where it's needed. In other words, if you don't understand a certain request, it's perfectly fine to ask, and probably a great idea to ask the CHSO via email, whether it's in person or even a telephone call, asking what exactly they mean by the request if you're not sure. Even if you think you know what they're asking for, make sure you make the call, make sure you make the contact and communicate to make sure that that's exactly what they asked for. Don't give any more than they asked for. Don't give any less than what they asked for. Never, ever give access to your computer files. And for the most part, if they are looking at your computer files, for example, they're actually looking at your computer maintenance management system, for example, if they're looking for your PSM software, et cetera, and they're looking at that gives them free rein to look at a lot of things that they probably didn't need to look at, and you don't want them to look at. Keep copies of all documents that you provide to OSHA. Doesn't matter what it is, make sure you keep a copy of it. Here's the other thing. Remember I said earlier that knowledge is important. Keep know your weaknesses and strengths. One of the most important things that you can do is understand where your ghosts are or where your skeletons are, et cetera. Sometimes you need to have a gap analysis. I'll talk later on about how much citations are right now. They're almost $14,000 each. You can do a lot of analysis for $14,000 and then find out where those gaps are. If you can spend less than $14,000 to save $100,000, that's a good investment. That's understanding where your weaknesses are, understanding where your strengths are. The other thing is let the CHSO lead, just observe. In other words, don't take over the inspection for them. I know I was on a number of inspections where the facility would have an attorney sitting in on the inspection, which is perfectly fine. But early on, the attorney would want to take over the inspection, want to tell you how the process is going to work. And that is never good either. Let the CHSO lead, let them tell you what they want, what they need, et cetera, to do their inspection. There may be more than one document request. In fact, there could be several. Like I said, if you have embedded documents, for example, in your SOPs, then certainly they will ask for more information. Be aware of what you're being asked for and why. If you're asked for a certain document, understand why you are being asked for that document. Certainly, if it's just basic information about your PSM program, that's understandable. But when there comes back a second request for documents, now you're probably looking at the CHSO is probably looking at something specific. So you need to understand why exactly they're looking at that information. You don't have to ask why they're asking for it. You need to understand. That's where your knowledge comes into play. If you do not have a document, answer the request anyway. Just don't do anything. For example, if you CHSO asks for a document, respond. We don't have that document available, or we're not exactly sure what kind of document or what this request is really seeking out. It's better to give something than nothing at all. Sometimes it's better to provide a document, even though it doesn't totally answer the question, than it does to just provide nothing at all to the request. And sometimes actually, I have been involved in situations where we have given OSHA documents that the only thing that really was in that document that really pertained to what they asked for was the file name. So, and believe it or not, OSHA accepted it, never went on to issue a citation. So give documents where documents are requested. Typically when the CHSO is done, and this is essentially how I operated when I was a compliance officer, I would look at all of the documents first. All the documents requests would be made. I'd review all of the documents and make additional requests if needed. Once I had all of the documents that I needed, then I would begin interviews. And of course, any information you can get out of the interviews is great information. Normally, most compliance officers will start with operators and then do technicians, et cetera. Employees may have a union rep present. In other words, if your employee, operator, technician, non-manager personnel can have a union rep available or with them if they want, but they cannot have a member of management, et cetera, sitting in on those interviews. Sometimes there have been cases where we have had attorneys sit in with the employee, and that's perfectly fine, even if that attorney has been appointed or paid for by the company. It's kind of frowned upon, but there's never been really a lot of pushback on that. Also, the employee can be subpoenaed, or they can be asked to come into the OSHA office and have the interview, just like managers can as well, depending on the environment. That's normally rare, but again, depends on the environment they're put in, et cetera. Management can have another member of management or attorney present for their interviews. Obviously, now management is being held accountable and is accountable for their employees. So therefore, management can have an attorney or another member of management present as well. Oftentimes I get asked, how long can OSHA be at your site? I've seen OSHA be at sites for as long as 5.5 months, and almost use the whole 6-month period just on site, but that's not normally the case anymore. I think since the refinery pleas were completed, OSHA's gotten this down into normally about 7 to 10 days total. If it's a smaller facility, small gas plant, small chemical plant, ammonia refrigeration plant, it might be 2 to 3 days when they're actually on site. And that's includes the walkthrough, document request, and then interviews. Excuse me. Another thing to remember is be engaging and be involved in the process. Don't just sit idly by and not understand why things are being the way they're going. You can ask questions. There's nothing wrong about you asking the question to a CHSO exactly what they're looking at, why that's important, etc. They're not necessarily here to beat you up per se, but they also should be there to help teach and coach and mentor as well in what they're looking for and why is important. Have knowledge of your program weaknesses and strengths. And I can't emphasize that enough. that if you don't understand your programs, it's pretty hard to understand exactly then what the compliance officer is looking at. Don't give away anything either. So if you have a skeleton in the closet, don't go open the closet unless you absolutely want OSHA to see exactly what you're doing. Then don't give anything away. Now, I will say that in every inspection that I know of, everyone should request and receive a closing conference. That closing conference may not be in person. A lot of times that closing conference can be over the phone. It can now, obviously, it can be virtual, but a lot of times it can be just the phone conversation where you have the closing conference. This is the time to ask questions and understand if there's going to be potential citations. During the closing conference, the compliance officer should go over anything that he or she believes will result in a citation, and then offer evidence and facts for any alleged hazards. If you know you're going to be receiving a citations, now is the time to provide additional information to address the facts of the hazard. So if you know that they ask for specific documents and they're about to issue a citation regarding to those specific documents, and you realize that, well, there was more information that you could have provided that would have addressed that, then now is the time to get that information to the compliance officer. What we want to be able to do is avert getting a citation if any way possible. It's harder to get rid of that citation afterwards than it is to never be issued the citation to begin with. So making sure we're providing all of the facts of the alleged hazard. I'm not saying that you just provide a whole bunch of documents at this point in time that has nothing to do with the alleged hazard. You want to stick to the facts. That's what we do in all of those document requests. That's the time to provide all of the factual data, but sometimes factual data gets missed or it's misunderstood along the way. Remember, these are alleged hazards. And in order for a compliance officer to issue a citation, there has to be certain elements that have to be met. There has to be an actual hazard. So they have to identify that hazard. That hazard typically is identified through the regulation. For example, if we're talking about a PSM, have you done your MI inspections according to Regagap? That's a PSM actual hazard that has to be addressed, and that's the regulation as well. You must have exposure. And what we mean by that is somebody has to be exposed to that hazard. So for example, if you have a remote facility out in the middle of nowhere and you do your walkthrough and recognize that there's a hazard there, for example, you have a wire that's exposed. It's exposed, but now you have to, the CHSO or the compliance officer has to prove that employee was exposed to that wire prior to you coming on site. So that's through an interview process. Normally, you'll just ask, have you been on that site? Did you notice it, et cetera? Normally, you can glean a lot of this information out of the interview itself. So if your manager is being interviewed, if that manager is asking for the interview notes afterwards or keeping notes themselves on the interview, you'll get a pretty good idea where the compliance officer is going to be issuing citations, because they are, at that point in time, they're gathering information on knowledge of the exposure. Again, present facts only. Again, I want to emphasize the statute of limitations is 6 months. So OSHA must issue the citation within 6 months of the time they open the inspection. And sometimes when we look at citations, in abatement, we can request more time, but we'll discuss that here in a second. Citations are normally delivered by certified mail. So if you're receiving a citation, it'll normally be delivered certified mail. Somebody signs for that, and make sure that if somebody signs for a document, it gets to the right people. You have 15 business days to respond. There was a situation I know when I was a compliance officer where the citations, we had not heard from the company in almost 30 days after the citations were issued. When we started to look into the reason why, we found out that the person that had received the mail, the citations, didn't get it to the right people, and it was still on the person's desk where they had put it. So at that point in time, it was past the 15 days, so they had no recourse other than to pay the citations. So you have 15 days to respond. You have three things that you can do: is pay the fine and abate the hazard. So you always have to abate the hazard. Pay the fine, abate the hazard. You can request an informal conference, or you can contest the citations. You must always post the citations and abatement plans immediately. So as soon as you receive the citations, post those citations at or near where the citation or the hazard is, and the plans that you have to abate that. I always tell all of my clients and anybody else who listens to me, always request an informal conference. Nothing wrong with that. Actually, it's the best opportunity for you to see exactly what OSHA has in terms of the actual hazard and facts that they have to support that, and gives you an opportunity then to make sure that you understand those things, but also allows you to negotiate the citation. Sometimes the actual citation can be withdrawn. Sometimes you can reduce the seriousness. So typical PSM citations are always serious in nature. So you can negotiate it down to less than serious. Sometimes less than serious citations come with lesser fines as well. So you can negotiate the fines. You can also negotiate abatement. And there's a couple of things about abatement that we can talk about, not necessarily how you're going to abate it, but how long it's going to take for you to abate it. For example, some citations, when those citations are issued, have an abatement date set at 10 or 15 days. Well, there are certain things that cannot be done that quick. It may take longer to do that, especially if it takes equipment has to be purchased and installed, or designed and installed and purchased, et cetera. So you can negotiate those abatement times. Remember, the abatement date basis, the abatement date itself is also used for the purposes of repeat violations. And what I mean by that, if you sign an agreement to abate those hazards by XYZ date, and XYZ date is surpassed, then you are subject and could be subject to a failure to abate or repeat violations if somebody was to come in and do an inspection in your facility shortly thereafter. Also remember the date that you sign an agreement on whether it's the abatement or whether it's a settlement agreement in the case itself, that date becomes the date in which from then on, if you have an inspection at one of your other facilities and they find that exact same hazard at those other facilities, those now become repeat violations. So it's always important to remember that when you ask for a abatement date, that date is met, or go back and ask for more time. So never let the abatement go by without abating those hazards. As I said earlier, serious fine currently is $13,653. A repeat fine is $136,532 each. So it can be pretty expensive fast when you have more than one or more repeats. Abate the hazard again at all your locations. If you're a company that have multiple locations, abate it at every one of them. Otherwise, like I said, those become repeat violations. Oftentimes during settlement, informal conferences, you can negotiate some type of settlement agreement. Oftentimes you can get your fines reduced by 40 to 50%. Oftentimes OSHA doesn't want to take these to court any more than you do. So they'll be willing to negotiate some discount on the fines. Never negotiate on the abatement though. If you've got a hazard, identified hazard, you still must abate it. Again, out of that will come a final settlement agreement that includes all of the dates. Everything has to be abated, etc. Again, abate a hazard as soon as possible. If you see the hazard and as the compliance officers walking through your facility and they see the hazard, abate it immediately. Again, request an extension if necessary. If you need time to abate something, it takes time, negotiate that or request more time. But be diligent about abating the hazard. If it can be abated quickly, abate it quickly. Don't ask for more time if the abatement requires you just an updated procedure or remove a hazard. They're not going to give you a whole lot of time for that. Also keep in mind the informal conference itself is not binding on either party. So both of you can show up to an informal conference. You can talk about the facts, you can negotiate abatement. At the end of the day, if you don't agree with what OSHA wants to do, you still have the opportunity to contest it. Contest all the citations or one or more of them, depending on what you came out of the informal conference with. When you contest it, it's going to go to administrative law judge to decide. So a judge will decide it for you in those cases. And let me go back over a couple other things. So typically, for those of you not aware, so if you contest the citation, it normally goes to administrative law judge. A law judge decides, and if you as an employer or company don't like the resolution by the administrative law judge, then you can appeal to the review commission, the OSHA review commission, which is a set of judges that will decide the case themselves. If the administrative law judge decides against you in that particular case, then you have one more, obviously another appeal, and that goes to the circuit court to decide. And of course, you can take it all the way to the Supreme Court if you want. I'm not aware of any cases that have went all the way to the Supreme Court from a PSM standpoint. Certainly, there are some cases that made it to the Circuit Court of Appeals, but I'm not aware of any that went to the Supreme Court. So knowledge is the key. And if I could offer any advice, I would say conduct a gap analysis. Especially, I look at, we work in a lot of different industries. Ammonia refrigeration, for example, is simple PSM. We see that as simple PSM. There shouldn't be no reason why ammonia refrigeration facilities should be getting citations. It's simple, it's easy. Just get a gap analysis. If you're not aware or don't understand what you need to do, it's easy to figure it out through a gap analysis. Understand what is required. I know that IR, if you're ammonia refrigeration, IR has a lot of information, a lot of standards that you can use to ensure that you're in compliance. Even with that, you have to make sure that you're applying those standards to what you have. API 510, 570, and a host of other rega gaps are out there for other industries. Those become a little bit more difficult to follow, understanding what you're required to do with each of those. Again, this is where the gap analysis comes into play. Remember, knowledge is not faking it. So if you don't know what you need to do, don't fake it. Everybody can see right through that quickly, especially a seasoned compliance officer with OSHA sees through that very quickly, and that really never ends well for you either. Get assistance if needed. You know, there's a lot of people out there. I know we do a lot of mentoring and coaching. A lot of people would call that, well, we provide some PSM coordinator responsibilities, but really it's a process in which we want to be able to mentor and coach those people that we work with so that they can do it on their own and that they understand what they need to do on their own. And I would rather see those people that we work with spend their money on improving their processes, making more product and improving their processes rather than paying the government for fines, et cetera. And again, if you're looking at a $14,000 fine, for just one citation, it doesn't take long to figure it out. Gap analysis is a great return on investment. Also, keep in mind, always document your inspection, as we went through this already. So document everything that you see along the way, document everything that the CHSO or the compliance officer sees along the way as well. And then lastly, always attend the informal comments or request an informal conference. You can never go wrong with that. In fact, I'm not sure I understand why people would not want to do the informal conference. Yes, it takes a couple hours of your day, but it gives you an opportunity to understand exactly what the problems are or what OSHA sees as the hazards, and you get an opportunity to certainly negotiate a better outcome than you would normally get. With that, I'd like to open it up for questions. If you want to ask me a question, feel free to type that question into the chat box or the questions box, and I'll be glad to answer those. Also, if you want to ask the question in person, just raise your hand and I'll see if I can unmute you so we can get everybody's questions answered. One of the questions that I currently have is, what do you recommend for viewing as an internal gap analysis? You mentioned the IR section, anything else? Well, just make sure that we understand if you're an ammonia refrigeration facility, yes, IR sections are going to be important. But more importantly, there are many different standards within IR, whether it's IR2 for design, IR6 for inspections and tests, and then of course you have 5, 4, 7, and 9 are some others that you'd certainly want to look at. So doing a whole PSM RMP gap analysis is certainly what I would recommend. That's looking at everything within your process. So if you're following IR2, then by definition, you'll also be following ASME Section 8, Division 1 Section 8 for vessels, et cetera. So if you're following that code and standard, then normally they'll reference the other codes and standards that you need to follow as well. If you're in an oil and gas or a petrochemical facility, then you're going to be looking at a whole set of new set of rega gaps, usually the API codes and standards, whether it's 510, 570, 526, et cetera. There's a whole bunch more rega gaps that you would have to review there. I think personally, of course, I'm a little bit biased, obviously, but I would recommend getting a third party to come in and do that gap analysis for you as well. So hopefully that answered that question. Another question I had is, what do I mean by mentoring and coaching? And what I meant by that is essentially, we have some companies that we help them set up, not their PSM programs. We can do that obviously, but most people by now have PSM programs set up, but they don't necessarily know everything that they need to be able to do in those programs. The other thing is we kind of help coach and mentor to the point where they can do it on their own. So once they're set up, We explain, teach, and coach what they need to do, how they need to do those things. And then at some point in time, whether that's a year, whether that's 2 years, they have then been able to take it over themselves, be the PSM coordinator, know exactly what they need to do and when they need to do it. Another question I have is are consultants ever retained or engaged during the inspection or in the review process? Yes, that's something we actually do quite often. Is we're engaged in the process or we get involved in those processes, but we tend to stay in the background. And that's where we want to be. We want you to be engaged in that process, but we want to be able to advise you on how to respond to different document requests, how to respond to different statements that they might have made, et cetera. So we're in the background kind of helping. Does that necessarily we need to be on site? No, most of the time we're not on site. Most of the time we're just, we can do it remotely and provide the insight that you need and to be able to respond correctly. Okay, got a couple more minutes. If we have any more questions, be glad to answer those questions for you. If not, as I'm waiting here a couple of minutes, I have my email address up there. Feel free to contact me if you have any questions at all. Be glad to answer those questions, point you in the right direction, or at least confuse you even more if nothing else. Hopefully not, but hopefully get you in the right direction, get you the information that you need. Again, I would prefer that you guys spend the money in your facilities rather than giving it to the government. They tend to spend our money a lot better than we do, right? So if you want to give it to them, perfectly fine, right? All right, all. Appreciate you taking the time to attend our webinar. If there are any ammonia refrigeration facilities on here today, I'm going to be doing a hands-on webinar the first of the year that's going to talk specifically about how to calibrate ammonia refrigeration transducers and also test your cutouts safely in a safe manner. And that's going to be probably the first webinar I've done that's really interactive or is actually showing a hands-on demonstration of how that's done. And hopefully you'll come join us then. Also, I had another question come up. Would you be able to help guide our company on mechanical? Oh, yes, absolutely. Mechanical integrity. I like to say that IR6 done a huge job in putting together all the things that you need to do. The only thing that that is totally clear, it is, but it's not clear to those that are actually the end users, is what mechanical integrity needs to include in piping and vessels, et cetera. Getting closer there, I think there's a lot of things that we can do in that industry to get better. I think you have API 510, 570, 580, and the other industries, ammonia refrigeration is getting much better too. And these new standards, IR6, that's come out is certainly a huge benefit in that direction. But certainly mechanical integrity are things that we do quite often. All right, if there's no further questions, I'm going to let everybody go. You all have a great afternoon. I look forward to you all joining me for some more future webinars. We're going to be setting up quite a few in the new year, talking about similar subjects as we talked about today, really helping industry, whether it doesn't matter what industry you're in, helping them to achieve process safety. That's what we want to help each and every one of those people that join us today. Thanks again. Talk to you soon.